Hello, dear listeners, to another enlightening episode of International Legal Scholars and Practitioners, the podcast where we engage with brilliant minds shaping the discourse of global justice. Today, we have the honor of sitting down in online format with Dr.Irem Sengul from Ankara Yıldırım Bayezid University, a distinguished expert in the field of international law, to delve into the intricate web of refugee law. Dr. Sengul is not merely an academic, she is a beacon of insight, tirelessly working to unravel the complexities of refugee law, a field where legal theory meets the urgent humanitarian needs of millions around the world. In the realm of international law, refugee law holds a unique position. It's not just about statutes, it's about real people and real lives. In this episode, we explore the foundations of refugee law through Dr. Sengul's experience, delving into its historical underpinnings and evolution. Welcome, dear Dr. Sengul. We're glad to see you in our podcast, and let me express my gratitude for agreeing and sharing your knowledge with us today.
Hi, thanks for inviting me. I'm really glad to be here, and congratulations for having this podcast series.
Thank you. Dear Dr. Sengul, with your permission, I will start asking about some aspects of refugee law. Please explain us what are the fundamental principles and historical developments of refugee law under international conventions and treaties, and how do these principles shape the legal landscape of asylum seekers globally?
So when we're talking about international refugee law and its historical development, we should start with the thing that international refugee law initially followed the developments in Europe, especially around two world wars. So the main international convention, which is repeatedly being affirmed as the key instrument of international refugee law, which is, we say refugee convention, but convention relating to the status of refugees of 1951, adopted at the end of the Second World War. And when we look at the definition of refugees, so who is a refugee according to the Refugee Convention in 1951, it starts with the words as a result of events occurring before 1951, before 1 January 1951. So it has a time limit. And it's also in the second paragraph give option to states to say events occurring before 91 in Europe. So it has a very European focus, right? So according to the 1951 convention, a refugee is a person, is an individual, as a result of events occurring before 1951, if states prefer occurring in Europe, is outside of his own state or her own state, country of origin, and has a well-founded fear of persecution. So she is unable or unwilling to return to the country of origin because of this well-founded fear of persecution. And this persecution is for reasons of race, religion, nationality, membership of a particular social group, or political opinion. So in this case, a refugee is outside of the country, has a well-founded fear of persecution, and it's before 1951, and for events occurring in Europe if the states prefer. So it has a very Eurocentric focus. But when we come to 1967, like almost 2 decades, nearly 2 decades after the adoption of Refugee Convention, we see that the protocol relating to the status of refugees universalized the convention. How? It removed the temporal, the time aspect, and the geographical, the spatial limitations. So there is no more events occurring before 1951 and no more events occurring in Europe. And later on, also we had regional arrangements like the convention adopted in African Organization of African Unity in 1969, Cartagena Declaration in Central America in 1984, and Arab Convention in 1991, all signaling that there are refugee protection mechanisms in regions, different regions. So what does Refugee Convention does? It's the cornerstone of refugee law. It defines refugees, as we mentioned. It sets out legal obligations of states, which is very important towards refugees. And one of the main legal principle is the norm of non-refoulement. Okay, when we are talking about refugee law, one of the main principle is the norm of non-refoulement, which, according to the Refugee Convention, Article 33, prohibits the return of refugees to territories where their lives or their freedoms are at risk. Okay, so it prohibits the return. Also, we had this norm, the norm of non-refoulement, established in human rights law conventions as well, human rights conventions. And in that case, in the human rights law, the non-refoulement mainly depends on right to life, the prohibition of torture. So if there is a risk of torture in a country, you cannot return a person to this country. And mostly, most international lawyers accept that non-refoulement, the norm of non-refoulement, has acquired a customary law status. So it is binding upon all states, regardless whether they are party to the Refugee Convention or not. Another important safeguard, so we said it defines the refugees, it protects against return, the non-refoulement principle. And another important safeguard set out in the Refugee Convention is that states are prohibited to impose penalties to refugees who entered their countries illegally or present in the country illegally, because otherwise refugees might not travel at all, right? So although they enter or be present in the host country illegally, they should not be penalized. This means they can travel without passports, right? They should not be penalized for not having passports, for example. So these two principles together secure asylum seekers' movement and mobility to be able to escape persecution and seek safety and refuge in other countries. And of course, after their admission, while they are present in the host country, their rights are protected by the convention. And maybe we can go further about these issues later, but I have to mention here that although these are the principles, in practice, we see the absence of effective implementation of such principles.
Okay, and how does the lens through which different nations perceive and evaluate refugee status vary? Geopolitical considerations, cultural contexts, and regional dynamics weave a rich tapestry that shapes the criteria employed by each country. What is the process for an individual to be granted refugee status under international law, and how do the criteria for determining refugee status vary from one country to another?
Starting with the international law, so the convention sets out the definition, but it doesn't explain how to grant refugee status, so how to determine the status of refugee, and this is on purpose actually, so because it's self-declaratory. When you fit the definition of the Refugee Convention, you are a refugee. But in practice, so states follow different procedures. So when we look at the definition of the convention, we see that one has to be outside of their country of origin. So if you are inside the country of origin, even though you face persecution, even though you leave your home and displaced within the borders of your country, so we label them as internally displaced people, not refugees, and they cannot benefit from the protection of the convention. Also, one has to have a well-founded fear of persecution, as we mentioned, depending on 5 grounds: race, religion, nationality, membership of a particular social group, and political opinion. But when we consider forced migration today, we see that it is a restricted definition, right? Many situations that lead to forced migration, so people has to leave their countries, such as armed conflict, maybe economic violence, gender-based violence, natural disaster, whatever it is, they are not covered by the convention's definition, the criteria in the convention. So we see that in some regional documents, the definition of refugee is extended to include different regional grounds for forced migration. For example, in African Union, external aggression, occupation, foreign domination, or events seriously disturbing public order. If you are displaced due to these reasons, you face persecution due to these reasons, then you can get refugee status. Or similarly, Cartagena Declaration in Central America includes generalized violence, foreign aggression, internal conflicts, massive violations of human rights, or other circumstances which lead to disturbed public order, seriously disturbed public order. So this wording, the event seriously disturbing public order, also has a potential, right, to be raised in various contexts. So you can argue that this is an event seriously disturbing public order. Nevertheless, there is no explanation in binding international documents on the process of refugee status determination. Yes, these are the criteria, but how about the process? At this point, I mean, it varies, as you say, from country to country, but we can talk about maybe general implementations, general procedures that are followed. One of them is individual determination of refugee status. Since the Refugee Convention defines refugees on an individual basis, refugee is an individual who has well-founded fear of persecution. So countries follow individual refugee status determination processes, and it might be conducted by state authorities, and these authorities might be border guard, police, migration officials, asylum decision makers, or judges, or it might be UN High Commissioner Refugees officials, UNHCR. So in some countries, UNHCR conduct refugee status determination. In the individual case, so the procedure is generally, it might vary from one country to another, but an individual applies for international protection, and then they are initially screened and registered, and then as the main part of the status determination, there is an interview, okay? So the asylum seekers put forward their experience of fear of persecution, their arguments for it, and then ask to provide documents if there are any. Maybe there is no document that they can bring forward. And the authorities gather relevant information, and the decision is taken whether to grant or not to grant refugee status. But at this point, we need to underline that in general, this procedure takes a long time. There's a long waiting period where asylum seekers wait for the decision in an uncertainty, right, in the feeling of uncertainty. Another approach, this was an individual approach. Another approach is a group-based approach, which is prima facie recognition of refugees. We call it as prima facie recognition of refugees, and it is mostly applied in emergency situations or when the numbers are high. So in that case, the authorities look at the objective conditions in the country of origin. It might be occupation, massive human rights violation, conflict, generalized violence, etc. And by taking into account these objective criteria, they provide refugee status to a group of people. An example is from Brazil. So the National Committee for Refugees, for instance, looked at the situation of Venezuelan refugees, the situation in Venezuela, and it came to the conclusion that it is accepted as serious and generalized human rights violations, and provided refugee status to Venezuelans on a accelerated, like simplified procedures, and recognized Venezuelans as prima facie refugees in 2019. This is an example. So it varies really from country to country.
Thank you. In cases where a person's claim for refugee status is denied, what legal remedies and appeals are available to them? And how do these processes work?
This really, again, depends on the country, right? So it varies. So I might give an example from Turkey, okay? Because in Turkey, there is right to judicial appeal, and we might look into the case, how it works. So according to the law on foreigners and international protection in Turkey, refugee status determination is conducted by a civilian authority, Presidency of Migration Management. And there are two procedures. The first one is a regular procedure. And when the asylum seekers apply for international protection, their interview is to be conducted in 30 days and the decision within 6 months. Obviously, this can be prolonged, and it is prolonged. I mean, it can take very, very long time. The second one is accelerated procedure, and it is applied when the applicant, when there are grounds that their application will be unfounded, right? So provided false documents, it is under administrative, the applicant is under administrative detention pending removal, or has previously removed from Turkey. So in these cases, the accelerated RSD, refugee status determination, is conducted. And it has to be, the interview has to be in 3 days, and the decision should be in 8 days. Whatever. When the refugee status determination is ended with a rejection, let's say they are rejected in accelerated procedure, then there is right to appeal, and these appeals should be submitted to administrative courts within 15 days. And the decision of the administrative court is the final decision. If it's a regular process and rejected, then there is option 1. The applicant can submit an appeal to administrative authority. Option 2, they can submit appeal to administrative court. And in this case, the onward appeal is possible. They can take the issue to the regional administrative court, which will provide the final decision. So this is an example from Turkey, and this is according to the law. The practice can be a little bit different, but this is according to the law. So this is an example how judicial appeal works when the refugee status, in the refugee status determination, it is rejected. But in other countries, there might not be judicial appeal, only administrative appeal. In some cases, there won't be any appeal, and it might lead to deportation, but we should be careful. So deportation without judicial review might amount to case of non-refoulement if the case is not dealt with adequate concern.
Okay. How do countries navigate their legal obligations to refugees when national security concerns or political interests conflict with the principles of refugee protection? Can you provide examples of such situations, please?
This is an important aspect, actually, to understand how the protection space globally is shrinking. And it is one of the main parameters behind the immobility of asylum seekers who are overwhelmingly staying within the immediate regions in the neighboring countries for the most of the time. National security, we are hearing this especially since 2001, the so-called war on terror declared by the US, and there is an increasing discourse on the national security in the global north countries who link refugees with terrorism, right? So in the global north, the discourse of linking refugee movement with terrorism is on the rise. And more recently, following the 2015 and 16 crossings at the Mediterranean, we see that, again, the global north countries are bringing in forward the arguments of national security. And what is the result? The result is the reluctance of those states to admit refugees. And they are adopting policies to keep them away from their borders. We can give the example of actually the former US President Trump's discourse and executive order, which is known as immigration ban or Muslim ban in January 2017. So the executive order that the Trump administration adopted called for stopping issuing visas to Syrian nationals and halting the process of Syrian refugees. So the executive order included 4-month suspension of refugee program, and it cut the refugee numbers that will be resettled to the US half by half. The only exception was people claiming religious persecution. So the order suspended all immigration from the so-called countries with terrorism for 90 days. And these countries are listed as Syria, Iraq, Iran, Sudan, Libya, Somalia, and Yemen. That is why the order is known as also the Muslim ban. So this is how national security discourse amounted to an executive order during the former Trump administration in US. So we can give more examples like this, but despite this repetitive link that provides a discourse linking terrorism and refugees and national security concerns in the global north countries, we don't have any evidence of that. So several studies underline that terrorism is quite a negligible issue among refugees. And we might look at international refugee law itself, the Refugee Convention, whether there are safeguards for states in times of national security and public order. So we see that the very first article of the convention, which defines refugees, also put exclusion clause and deny refugee status to those who has committed a crime against peace, war crime, crime against humanity, or serious non-political crime, or guilty of acts contrary to the purposes and principles of the UN. Too short, I mean, this is so basically those who pose a threat to national security are excluded from refugee status. Furthermore, states can take provision measures, for example, detention, that they are normally prohibited to do so, of a refugee when it considers that such a measure is essential to the national security in exceptional circumstances. Again, states are permitted not to provide documents for travel outside of the territory to refugees for national security and public order. Article 32, very important safeguard prohibiting expulsion of refugees, put an exceptional case and allows expulsion in cases of compelling reasons of national security and public order. So in other words, by the way, these should be interpreted restrictively, okay, to protect refugees. But in any case, the refugee law, the refugee regime is not designed as a backdoor for hampering national security of states. It's on the contrary. The whole idea of refugee regime, the refugee law, finding protection for refugees, finding durable solutions for displacement is to keep international security and order in place. That's the whole idea.
Mm-hmm. Okay, and could you discuss the legal concept of subsidiary protection and how it complements the protection of refugees under international law?
Okay. So subsidiary protection, it's a legal concept. It is rooted in European refugee regime. So when we are talking about who is a refugee, we said that the definition of the Refugee Convention is a restrictive one. It does not cover every situation that people are forced to leave their countries. In some cases, they do not fit into the definition of Refugee Convention because of this, like 5 reasons of persecution, right? we also mentioned that, I mean, if what will happen to these people if they do not fit into the Refugee Convention, but they are still in need of protection. They are still in need of international protection. They are forced to leave their countries. So in the European law, for those who cannot obtain refugee status, but who are in need of international protection, they are provided with subsidiary protection status. It is regulated in the qualification directive, and according to the directive, the subsidiary protection is provided to a person who does not qualify as a refugee, but if she is returned to the country of origin, she will face a risk of suffering serious harm. So there is risk of serious harm, but the person cannot satisfy the criteria of Refugee Convention, but there is need of international protection. So it becomes crucial to know serious harm, right? What is serious harm? Because in that case, that a person can get subsidiary protection. According to the qualification directive, serious harm is defined as consisting of death penalty, torture, or inhuman or degrading treatment or punishment, or serious or individual threat due to indiscriminate violence of conflict. So if there is torture, risk of torture, inhuman or degrading treatment, or an armed conflict, then a person can obtain subsidiary protection status. This is an individual status as well, like refugee status. So people do not, I mean, a person do not apply either for refugee status or subsidiary protection. They apply for international protection. And during the status determination process, they might get refugee status, they might get subsidiary protection status, or they might be rejected according to their cases. Obviously, subsidiary protection provides protection against refoulement, so the principle of non-refoulement, and it entails protection of human rights, and there are standards of treatment similar to refugee status, but there are some differences. In practice, for example, like the treatment of refugees and treatment of beneficiaries of subsidiary protection might differ for the waiting periods of family unification, validity of their residence permits, access to welfare systems, etc. But here, as you mentioned in your question, it is important to underline that it's a complementary status. It is not a substitute for refugee status. So if a person can obtain refugee status, she should obtain refugee status. It is not a substitution, but it's a complementary way, yeah, for those who cannot satisfy refugee status.
Okay, thank you. And what are the legal obligations of countries in providing asylum to refugees and ensuring their access to basic rights, including education, healthcare, and employment?
So we talked about non-refoulement. This is one of the main principles of refugee protection. I will not go into detail of it again. But in addition to non-refoulement, states also agree to provide certain facilities to refugees, such as administrative assistance, identity papers, travel documents, and so on. But your question, the access to rights like education, healthcare, and employment, also is related to conventions call for naturalization, the facilitation of naturalization. So obviously, access to rights is human rights of refugees, and it is universal, whether you are a refugee or not. Your human rights, you have human rights. This is about like facilitation of human rights, but also it is about facilitation of naturalization, which the convention is calling for in Article 39. So it's about integration to host country, related to integration to host country, which is one of the durable solutions to forced migration. So the convention, the Refugee Convention, focuses on social security, rationing, access to employment, and professions in this regard. When we look at the convention's wording, such rights are accorded to refugees at a standard not lower than other non-citizens. Okay, so the standards of treatment should not be lower than non-citizens in the country. In some, such as right of association or wage earning employment, the convention calls for most favored nation treatment. In others, it calls for treatment on equal level, no different than accorded to citizens. And in this rights, such as artistic rights, industrial property, freedom of religion, access to courts, rationing, access to public education, as you mentioned, public relief and assistance, social security and taxes. So in these, the standards of treatment should not be lower than the citizens. Nevertheless, when we look at the state practice, we observe that most of the time, states are reluctant to provide socioeconomic rights, to hamper integration, actually. So in practice, let's say housing, access to housing, social benefits and employment are restricted, and it varies from state to state, obviously, but these are the most restricted rights we can say.
Dr. Sengul, how do regional refugee protection mechanisms such as the European Union's Common European Asylum System interact with and complement international refugee law?
Okay. Oh, yes. So regional arrangements are important tools, right, to discuss different mechanisms and to understand appropriation of refugee law in different regions. And I think to an extent we mentioned some of these. We mentioned how definition of refugees are extended in African Union and in Central America, and how in these regions there are practices of prima facie recognition of refugees. And we also mentioned about EU on subsidiary protection, right, to complement the international protection as a complementary means of providing international protection. But here, since you mentioned Common European Asylum System, we might talk about another mechanism that is in effect in Europe, in the EU, which is temporary protection. So temporary protection is formulated in international refugee regime. It is formulated mainly through soft law instruments, such as UNHCR Executive Committee conclusions and guidelines. And we see in the state practice as well. So it's an exceptional response, not a regular one. And it is provided during large-scale displacement, which is called mass influx. In 2001, the EU Council Directive incorporated temporary protection in the Common European Asylum System. So since then, it is part of the Common European Asylum System. And it is to be provided when there is a mass influx and there is a risk that asylum system of countries in the EU will be unable to process the refugee status determination of individuals, right, to process this influx. How it works, so the EU Council adopts temporary protection for a specific case by a qualified majority, and then certain group of people, not an individual, a group of people, are accorded with temporary protection status for a temporary time, right? It's a temporary one. It is standardized as 1 year, but it can be prolonged up to maximum 3 years. The standards of treatment include residence permits, access to employment, housing, social welfare, education, etc., family reunion to an extent. When it is terminated, for example, let's say the maximum duration reached, or a qualified majority of the council adopted for its termination, then individual applications for international protection this time should be processed. Okay, so the group-based temporary protection terminates. individual applications then should be processed for international protection, refugee status, subsidiary protection status. As I said, it's in 2001 that the EU adopted it, and since then, time after time, its activation was discussed. For example, for Afghan refugees, for refugees from Iraq, refugees from Afghanistan in 2001, 2003, after the refugee movements from North African countries, another debate. Most recently for Syrian refugees, another debate and calls for activation of temporary protection, but it was not activated in these cases until 2022. In March 2022, it is activated for Ukrainians, okay, people escaping Ukraine. So if we go back to your question, we can argue that European Union common European asylum system is obviously based on norms and principles of international refugee law. It incorporates Refugee Convention, its principles, but it also brings forward the idea of subsidiary protection, temporary protection as an exceptional measure to complement it, right? So it interacts with refugee protection by first adopting it and then providing other statuses as well.
Okay. And can you share insights into the role of domestic laws and courts in the implementation and enforcement of international refugee law? And how do countries ensure compliance with their legal obligations?
So as a general norm, we can say that every state's party should implement international obligations in good faith. And should incorporate refugee conventions, norms and principles into domestic law. This is how it should work. In other words, like the implementation and enforcement of international refugee law occur at national level, right? And many countries incorporate international refugee law into their domestic legal systems through legislative acts. In this picture, the courts, judges and lawyers first of all, play a key role to ensure that refugees are treated equal before the law. So they are not target of discrimination. So there is no discrimination between citizens and refugees. When we consider refugees' arrival and presence in the country, we can argue that courts play a significant role from the beginning. Any removal, any deprivation of liberty, like detention, should involve a fair and effective legal procedure. It should be subject to judicial review. And when we consider entitlement of international protection, we discussed the refugee status determination procedure should be subject to effective appeal, right, judicial appeal, by an independent and impartial judicial authority. If there is a violation of human rights of refugees, like all other persons, always there should be right to an effective remedy and reparation. And it includes access to courts, obviously. So countries should ideally incorporate principles of international refugee law into their domestic national legislation and provide access to courts, access to legal aid, legal representation for refugees. And it should include, it is not limited to, but it should include cases of removals, detention, appeal for status determination, or human rights violation.
And my last question, what are some recent developments or changes in refugee law, both at the international and national levels, and that have influenced the protection of refugees? And how have these legal changes impacted the refugee landscape?
So since the start of our talk, I mentioned the Refugee Convention a lot repeatedly, but it's the case, it's still the case. So it is reaffirmed as the key instrument for several times. But nevertheless, contemporarily, I mean, recently, we are also talking about failure of durable solutions. So refugee status is a temporary status. One should not be refugee for long times. There should be a durable solution for displacement. Traditionally, we are talking about 3 different durable solutions, which are voluntary repatriation to country of origin. So people returning back to their country of origin voluntarily because there is no more persecution, risk of persecution there. Integration into host country where they are staying, and resettlement to third countries. But when we look at the numbers, the statistics, we see that the durable solutions are relevant only for very small percentage of people. According to UNHCR statistics, for example, there are more than 100 million people who are forcefully displaced. And this includes refugees, asylum seekers, internally displaced people, and others who are in need of international protection. Out of 100 million, 35 million are refugees, according to the UNHCR statistics. And when we look at 2022, last year's numbers, we see that only around 300,000, 340,000 people repatriated to their countries, and only 100,000, 115,000 people were resettled in third countries. So comparing to the numbers of refugees and displaced people worldwide, this is very small percentage. So what happens when we don't have any durable solutions? Most refugees, 70%, are hosted within their immediate regions by neighboring countries such as Turkey, Iran, Colombia, or Pakistan. What is the reason for this failure? Why we are talking about failure of durable solutions? Because it requires international solidarity, which is lacking. So there are no responsibility sharing, meaningful ways of responsibility sharing among states. And there is no binding convention resolution that calls for international responsibility sharing. Actually, when we look at the Refugee Convention, its preamble acknowledges that the grant of asylum may place unduly heavy burden on certain states, and the solution should be international. There cannot be a solution without international cooperation. But when we look at the main text, we don't see binding reflection of such a call. But recently, going back to your question, recently there are soft law instruments such as 2016 New York Declaration, 2018 Global Compact on Refugees. They are dealing with issues of protracted displacement, large-scale displacement, solutions and responsibility sharing, cooperation and solidarity among states. Among key stakeholders, actually, not only states, but including other actors as well. So, for example, Global Compact on Refugees obviously repeats the traditional norms and principles of refugee law, asserts that they are important. But it also acknowledges that there is unequal responsibility taken by states who host large numbers of refugees. So what it does, it tries to bring together stakeholders, different actors, including states, international organizations, non-governmental organizations, development actors, private sector, and refugees. This is important, refugees themselves, bringing them together to realize 4 main objectives: easing pressures on host states, enhancing refugee self-reliance, access to third country solutions, and support return to country of origin in safety and dignity. And all these require responsibility sharing, cooperation among actors. But again, I have to say it's a non-binding document, and there are some criticisms or cautions that it might be over-optimistic, or there is no implementation in national level. There are some criticisms on that issue, but I find it very important that it acknowledges the problems at least. So we will see if there will be solutions to these problems in the upcoming years, but its acknowledgement is important.
And as we conclude this captivating episode of International Legal Scholars and Practitioners podcast, I want to express my deepest gratitude to our esteemed guest, Dr. Irem Sengul. Today, Dr. Sengul has not only shared her vast knowledge of refugee law, but has also gifted us with a profound understanding of the human stories that weave through its intricate tapestry. Dr. Sengul, thank you for sharing your expertise, passion, and the compelling narrative that underscore the importance of refugee law. Your commitment to justice and compassion resonates, and we are truly honored to have had you on the podcast. Your insights have illuminated the path through the complexities of international law, reminding us that at the heart of every legal principle is a narrative of resilience and hope. Your dedication to bridging the gap between legal theory and human experience is truly inspiring. Thank you very much. To our listeners, thank you for joining us on this intellectual journey, and I hope this episode has not only deepened your understanding of refugee law, but has also ignited a sense of empathy and awareness. As we close this chapter, let's carry forward the wisdom gained today, fostering a world where the pursuit of justice is synonymous with empathy and understanding. This was International Legal Scholars and Practitioners podcast. I am Dr. Mokhinur, and until our next exploration into the realms of international law, stay informed and stay compassionate. See you on our next podcast. Thank you. Bye.